So with that, we'll get started on Know Your Solar Rights in Missouri. Oops. My name is Eric Schneider. I'm the Director of Business Development here at Straight Up Solar. I'm also a member of the Missouri Solar Energy Industries Association. That organization was helped lobby for the passage of this solar property rights bill that we'll learn more about. I'm also a NABCEP PV associate as part of my credentials and knowledgeable about the solar industry. We're really honored to have Steve Jeffery here with his 35 years of environmental law and litigation. His practices include litigation, regulatory compliance, and representation before state and federal regulatory agencies. He's argued environmental cases in front of the Missouri Supreme Court. And apropos for this week, he's a Navy veteran. So Steve, thanks for your service, your 23 years
Thanks.
with the Navy Reserve. A little background about Straight Up Solar. We were founded in 2006 by an orthopedic surgeon, Dr. Dane Glick, and Dane was very much concerned about what mountaintop removal and coal mining was doing when in Western Kentucky, where he was doing his residency. So when Dane founded this company, he really wanted to extend the notion of caring beyond his medical practice out to the community. So all 115 employees of Straight Up Solar believe in our vision to care for others by creating a path for clean energy and a sustainable economy that honors our values and everyone's healthy shared future. Our vision is why we exist, and we put this vision into practice through our clear values. Community first, lead the solar tribe, educate, advocate for solar policy, respect each other and the environment, and excellence in all we do. We ask all our customers and everybody we interact with to hold us accountable for these clear values. And I'm excited to have this presentation, this webinar, because it hits on two of our values of educating the population about what's going on in solar and then advocating for a fair solar policy. A little more background about Straight Up Solar. We were founded in 2006 and we serve all of Illinois and eastern part of Missouri. We've done 1,900 installations to date, totaling up 34 megawatts. We do residential rooftop and ground mounts, small businesses and large PV systems. We do battery storage for battery backup when the sun goes down, smart panels, which allows you to moderate which circuits are working in your home. We do electric vehicle charging, and we also are service and maintenance providers for all the systems, whether it's residential, small business, or large PV system. We're considered an EPC firm, which stands for engineering, procurement, and construction, which means that we're a turnkey installer. We're going to be able to take you all the way from the design of your home, all the way to the installation, and then to the service. And we're really proud to have that full spectrum of service to our customers here. We're part of the Amicus Solar Cooperative, so even though we're a small company here, located here in Maryland Heights, we're part of a broader network of 71 independently owned solar companies that allows us to purchase our panels and all our materials at a group buy rate instead of just going individually on the market, and allows us to kind of swap best practices and deliver those best practices to our customers here in Missouri and Illinois. Really proud to say we are a certified B Corporation, which means that we're measured by a third party to make sure we have a low environmental impact. And we're also bettering our community and making sure that our business can be a force for good in the world here. In addition to services on people's panels, we also do operation and maintenance and asset management for people who own large systems. And I mentioned we are a 115 employee company, and nearly half have that NABCEP certification here. At the bottom, you see some of our certifications that I mentioned that we're active in the Missouri Solar Energy Industry Associations and the Illinois Solar Energy Association, advocating for good public policy for solar homeowners here. So tonight we're going to talk about Missouri's new solar property rights law for homeowners, what it means if you live in a homeowners association, what are the implications of this law on municipal ordinances, and then what can homeowners do who live in a homeowners association. So with that, I want to turn it over to Steve, give a little more biography on himself, and then we'll launch into what this law, why it was passed, what it means for homeowner associations, and what it means for ordinances. Then I'll come back and we'll take your questions. So Steve, I'll turn it over to you, and thank you very much for joining us tonight on this webinar.
Eric, thank you so much for the kind invitation. Hello, everyone. It's my pleasure to be here with you tonight. Let me just give a little bit of background about Jeffery Law Group. It was founded in 2011. And particularly one thing I really have enjoyed practicing in is the cases involving solar and matters involving solar energy. For example, back in 2012, there was a lawsuit filed by several industry groups in Jefferson City challenging various provisions of Proposition C. Some of you may recall Prop C was passed, I believe, in 2008. And amongst other things, it created a lot of solar provisions, one including the solar rebate provision. The Public Service Commission enacted some rules for, and Ameren and KCP&L were required to issue rebates for solar installation. Anyway, several industry groups challenged various provisions of Prop C, including the solar rebate provision. They didn't think things like that should be subsidized. A judgment was entered, but before the judgment became final, we represented MOSIA. MOSIA intervened in the case, and we persuaded the court to undo the judgment. And the net result was the solar rebate provision was saved. So solar rebate provisions remained in effect for several years until, I guess, ultimately Ameren and KCP&L expended all the funds that were allocated for that. In addition, we've represented several homeowners in several solar panel lawsuits. For example, a case some of you may have heard about is called Babb versus City of Clarkson Valley. This is a case out of St. Louis County. There was another case in St. Louis County, Babb versus Kerrs Mill Estates. As you can tell by that, Jim and Frances Babb live in a subdivision in Clarkson Valley. They wanted to do a solar install. They initially got some pushback from their homeowners association, who convinced the city to be the front to deny them a building permit. And there was no ordinance in effect that the city could really do that on, but they did anyway. So a lawsuit was filed. We prevailed on that in the circuit court, and that case was affirmed in our favor at the Court of Appeals. At that point, they completed their installation. Shortly thereafter, their homeowners association filed a lawsuit saying under our covenants, you have to tear it all out. So anyway, that case was tried before a circuit judge in Clayton, and she entered judgment in favor of the Babbs and against the homeowners association. One of the significant takeaways from that, as I recall, there was like 180 homes in that subdivision. And the HOA board conducted a mail ballot poll of all of the homeowners. And the question on the ballot was, should the HOA sue the Babbs and incur a special assessment in order to force them to take their solar panels down? And that was overwhelmingly voted down. And so here the members of the association vote that question down, but the HOA files the lawsuit anyway. So that was one of the prominent features that the judge focused on, is that, well, if you have an organization comprised of all these members and none of the members want or agreeing with what their board of directors did, that's enough reason to dismiss the case. So that's what ultimately happened. Another case out of St. Louis County was Hoggy versus Highlands of Chesterfield. Brian and Susan lived in a subdivision in Wildwood off of Wild Horse Creek Road. They installed some panels. Their HOA brought a lawsuit to force them to take them down. That case again was tried on motions in front of Judge Jameson in St. Louis County, and he ruled in favor of the homeowners. And in that case, the basis of the decision was, if you look literally at the language and the scope of the restrictions in the covenants of what they applied to and what they prohibited, solar was not expressly enumerated. There was no argument that the plaintiffs could claim that solar was even covered by any aspect of the indenture. So that was the basis. One of the bases that the court used to dismiss that case. And there's been, a handful of other cases from St. Joe, all the way from St. Joe and South County. We've been involved in, as far as I know, more solar cases than any other attorneys around. And again, our practice is focused primarily on environmental law and environmental litigation, and promoting progressive ideas like this. And again, it's my pleasure, Eric, to be here.
So the bill was passed this year and signed into law, SB 820, and I will put a link into the chat if you wanted to kind of read the bill. Well, the bill essentially prohibits homeowner associations from limiting or prohibiting the installation of rooftop solar or solar PV systems here. The bill, when it was passed and signed into law, the legislators wanted the homeowner associations to have time to adapt their regulations to comply with this new law. So it's effective January 1st, 2023. So let's specifically go into what it says here. It allows HOAs to adopt reasonable rules regarding the placement of solar panels, as long as those rules do not prevent the installation of the system, impair its functioning, restrict its use, or adversely affect the cost or efficiency of the solar panels. So it provides a lot more rights to people who live in homeowner associations who are interested in going solar. But this law comes with it some past case law that Steve just mentioned. So let me turn it back over to Steve to kind of go over some of the other case law that this new law will fold into, and then the combination of this will then provide more rights to solar property owners. So let me turn it back to Steve here. There you go. Steve, you want to talk a little bit about specifically about the BAB ruling does to me?
Sure. Again, the BAB case in the Court of Appeals opinion, although the BAB situation, there are really two cases. It involved a dispute with the city, and it involved a dispute with the homeowners. The Senate Bill 820, the provisions that Eric just talked about, they deal with limitations on what an HOA can do in the HOA indentures or covenants. Senate Bill 820 really doesn't address what a municipality can do, with regard to adopting municipal ordinances dealing with solar. And this issue was specifically, addressed by the Court of Appeals in the BAB opinion. And Eric has a quote from the case up here. It says, while the state may not really have any concerns and have no restrictions concerning the use of, for example, the type of reflective materials that are on solar panels, where they can be seen from, but it says these areas can be of concern to a city, although the state, the Public Service Commission and the Department of Natural Resources, they could, they really just don't have a dog in that local fight, whereas a local municipality can. The Judge Witt, when he wrote this opinion, he did want to point out that, a city can address certain things under what's called its police power. Under the Missouri Constitution, cities as political subdivisions of the state have certain police powers that they have. And one is, protection of property values, protection of public safety, concerns such as that. So as long, in the event that a city wants to have some type of municipal ordinance that has some type of restrictions on that could be applicable to a solar installation, there has to be some type of articulable standard that, that this in policy goal that the city has, that the city is trying to achieve in adopting those particular provisions in their specific solar ordinance. For example, if a city has an ordinance that says, well, anyone who wants to put solar panels on the front of their house is required to get a conditional use permit. But then they have a policy that, well, we don't issue conditional use permits to solar panels located on the front of the house. That's a completely circular argument. So that would, there'd be very strong arguments that an ordinance like that would be what's called legally arbitrary and capricious, quote unquote, meaning there's really no valid, legitimate police power goal that that particular provision in an ordinance would have in it. However, for example, on the other hand, to contrast this, if, say, for example, there is a municipal ordinance that says, well, if a business, or whatever, along a neighbor or residential neighborhood that's located along a major residential thoroughfare, state highway, something along that line that has a lot of traffic on it, that's situated a certain way that sun, morning sun or afternoon sun could possibly reflect off some installed solar panels on a rooftop or something, for example, to cause glare to oncoming drivers. That possibly could be an example of something that Judge Witt's opinion would, someone could make the argument that, well, something like that would possibly could hold muster, as opposed to something that's totally arbitrary and capricious as well. We just don't like them on the front of the house, or we just don't like this color, or we don't like this shape, something like that. There has to be some articulable legal reason that backs up what the restriction is in the municipal ordinance. So that's what the BAB opinion says about what a city can do to regulate solar. Then there's some other cases that talk about what really can homeowners do, or a homeowners association can do. And again, based on my experience, I have not encountered a set of indentures or covenants that is exactly the same as any other set of indentures or covenants. Each one is unique. Each one was written probably 20 or 30 years ago by a real estate attorney that had no concept of solar or PV panels, anything at all like that. So that's some of the issues that these old indentures and covenants create. But when a court has to look at one of these sets of indentures, there are certain legal principles that courts will follow. And the first point is these restrictive covenants are really, it's just a private contract between a property owner and the homeowners association. When someone, when a subdivision developer develops buys some former agricultural property, subdivides it for residential lots, and builds homes there, and they 99.9% of the time they will impose a set of restrictive covenants, indentures, covenants, whatever you want to call them, on that property, and that are applied to each individual lot and each individual property owner. So if someone buys that lot, they buy the lot subject to the terms of whatever that contract, those indentures say. And since it's really a contract between the property owner and the HOA, as any other contract is construed, not only in Missouri, but across the country, the courts apply, what are called rules of construction, which, just like they were interpreting any other kind of contract. Eric, could you go to the next slide? And actually this quote is, all these quotes that I'm talking about here about what an HOA can do, these are taken out of the judgment that Judge Jameson entered. Judge Jameson was the circuit judge in St. Louis County and Clayton that entered judgment in favor of the homeowners in the dispute in the subdivision that was located just off Wild Horse Creek Road in Chesterfield. In this case, as a background, their indentures, it created an architectural review board, and it gave the architectural review board certain authority. And it specifically listed, I believe it was 18 specific types of items that if a property owner wanted to construct any of these enumerated items, they were required to submit those plans and specs to the architectural review board for review and approval. Okay, because this was, it wasn't a new subdivision. It was, it had been around for 20 years or so. The indentures and the covenants didn't consider solar. They didn't address it at all. Any of these, solar was not a specifically enumerated in any of these 18 items. So the argument that that we made in defending that case was that there was no requirement for the property owner to submit anything to the Architectural Review Board, because that board only has jurisdiction over projects involving these 18 specific items, and it doesn't list solar panels. So they don't have any authority to do anything about solar panels. And that was one of the arguments that ultimately prevailed with Judge Jameson. So again, these are just some quotes from that judgment that the court found that that the homeowners association didn't allege how the solar panels are subject to the provisions in Article 6 of the covenants. They didn't show how the trustees have the power to enforce a decision made by the Architectural Review Committee. In this particular case, because there was no plans or specs submitted to the Architectural Control Committee, they, quote, disapproved, unquote, the installation. And then they turned it over to the board of directors for the HOA to bring the lawsuit to enforce the Architectural Review Board's decision. Okay. However, the indentures didn't contain any provision at all that gave any authority to the board of directors to file any kind of lawsuit to enforce a decision of the Architectural Control Committee. So that was another ground that Judge Jameson relied on to dismiss their case. So the takeaway here is that in analyzing these indentures, it's important to to look at the language used in each set of indentures, because as I said a few moments ago, I've never seen two sets of indentures that are the same. They generally have the same type of concepts, but each one is going to stand on its own. It has to be analyzed on its own, because there could be, for example, the indentures in the Babb case had certain provisions in it, but the indentures in the Highlands of Chesterfield case, they had different provisions in them. And some of these other cases I had, their indentures say something totally different. So the important takeaway here is for someone who wants to do a solar install, the first thing you need to do is check to see what your indentures say. What authority? Is there an Architectural Review Committee? Does the Architectural Review Committee have jurisdiction over solar? If it doesn't, there's a strong, argument that you don't have to submit any kind of plans or specs to that entity or get its approval. If there's, if it's written, if the indentures are written such that the solar plans and specs have to be submitted to the Architectural Review Committee, what kind of standards and guidelines does that entity use to evaluate a solar install, the plans and specs? There has to be some type of enumerated standards, because the courts employ just general rules of construction that apply to any type of contract in Missouri. One party to a contract just can't arbitrarily make up stuff that's not in the contract to enforce against the other party. The courts don't let people get away with that. And so really, this is the citation to the case number in St. Louis Circuit Court. And in this case, the trustees, after they lost, they did not file an appeal of this particular case, I recall. But anyway, this is good language out of their judgment. And again, the takeaway is where it says Article 6, Section 6 does not provide the trustees the express power to bring the subject lawsuit. So that was the bottom line. The court looked at the indentures. The indentures didn't give the Architectural Review Committee any authority over solar. It didn't give the trustees the authority to enforce an action to take down solar panels. So the trustees ended up losing that.
Thank you, Steve. That
Sure.
was great. We'll just conclude here, and we have 3 questions. I'm just going to do a couple concluding slides here. If now that you know kind of your rights a little more in Missouri, what you can and cannot do, what the new law allows people who live in homeowner associations, you might want to be interested in getting a solar site assessment for your home. See if solar works for your home here. We have a great staff of solar support specialists who can walk you through and start you on the process here. All we need is your utility bill and an identification of where your house is located in terms of the angle of the house relative to the sun. We'll get you started and pass you over to a project developer who can set up a customized plan that will have a cash flow statement of where your energy savings comes in and what year. He or she, our project developers, will explain the incentives that are currently out there. As you may know, the 30% tax credit has now been extended for 10 years at the federal side, and Ameren, Missouri has a $250 per kilowatt rebate for homeowners in Missouri. So right now is a great window of opportunity to go solar. If you like the plan that we developed for you and you sign a contract, we'll put you into our project management stage, and we'll assign you a project manager who will do the design work. We'll file the permits. We're going to stand in line. Again, we're a total turnkey operation. You just have to sit on your couch and watch us do all the work until our crew comes out to install your home. It usually takes us 2 to 3 days to install a typical solar array on a rooftop here. We're pretty fortunate right now. Our queue is set up for April. So if you talk to us now, we'll have you all ready for the peak of summer season here, and you'll start not have to experience some of the rate increases that Ameren did last year, because you'll be all set with solar. And then once you get your solar array, you get your bi-directional meter working backwards and forwards, you're trading your energy between your house to the grid. You'll be so happy. You're going to do our solar pose and catch the power of the sun into your house here and be a proud solar homeowner. I'm going to drop a little note here in the chat. If you're interested in getting your solar system started, feel free to click that link and we'll get you started on an estimate here. With that, here's Steve's contact information. He's at sjeffrey@jefferylawgroup.com. Feel free to contact me if you have any questions about straight up solar or future topics for a webinar. That's my contact information there at eric.schneider@straightupsolar.com. With that, I'm going to stop sharing my screen so we can see Steve's face a little more. And I'll kind of bop into the question and answer. Steve, you ready to answer? We have 5 questions here from.
I think the questions are going to be for you, Eric. So
the first question is, what was the basis of the HOA lawsuit? This goes to you, Steve, maybe the first one. And why did they want to take it down?
in which lawsuit?
I think it was in the BAB lawsuit he's referring to. The first.
Okay. Well, really, I think in the common theme here is that a lot of the people who serve on these HOA boards as trustees or directors, different indentures call those folks by different names. Sometimes those people just aren't really educated about solar, how it works, what the benefits are. The fact that there's been significant amount of research studies around the country that have determined that solar installations do not devalue property values in neighborhoods. I think sometimes these trustees just do a knee-jerk reaction. Well, if this is something new, we don't like it. So invariably in both of the St. Louis County cases I talked about, I think that's probably a good category to put those trustees in. They just didn't like solar and they didn't want it in their neighborhood. They didn't want to establish a precedent because they're afraid everybody else would start putting solar up, and that could possibly have an effect on their property value. So it's basically just lack of knowledge and possibly some unfounded concerns or fears about what might happen in the future. So I think that was really the mindset that these trustees, had going into their, what led to their decision making to initiate these lawsuits. So hopefully that answered the question.
Thanks, Steve. The next question is, what if there are no standards from the HOA other than they have to approve it, and they've denied that application simply based on them not approving the application? Not quite sure, maybe the person, Benjamin, if you maybe could rephrase that question, I'm not quite sure what you meant here. I guess said if there's no standard from the HOA other than they have to approve it and they still denied it, what's kind of the next steps for the homeowner, Steve?
Yeah, I think this could be a scenario where, and again, as I said, each set of indentures has to be analyzed on its own because no two are going to be alike anywhere. Okay. So let's say we have a hypothetical set of indentures and it has, some general provisions in it that, well, if a property owner wants to build a structure, it doesn't identify different kinds of structures, but they want to build a structure on their property, they have to submit the plans and specs to a architectural review committee for review and approval. And then, it may not enumerate any specific standards for what the how the architectural review committee evaluates these. Sometimes, indentures also have provisions that well, if someone submits plans and specs on day one, if the architectural review committee doesn't take any action within X number of days, the plans are deemed automatically approved. Some indentures say that. On the other hand, some indentures say, well, if they don't make a decision with X number of days, it's automatically disapproved. So again, it's not really possible to answer with any degree of specificity a question about what indentures say without looking at a specific set of indentures. I'm not trying to be evasive or anything, but I just can't give a specific answer on a very general question like that. Although it is a good question, but it's a general question that needs more specific facts to give a good answer for.
Yeah, kind of going back to your point, no two indentures were the same in your
exactly.
Our next question is, when a resident wins a case against an HOA, does the HOA have to reimburse the resident for the expense incurred from the lawsuit?
Again, that's a good question. Courts in the US follow what's called the American rule, which means parties involved in a lawsuit they each pay their own legal expenses, costs and expenses. The two exceptions to that general rule is if there is a state statute or a federal statute that says the prevailing party is entitled to recover their attorney's fees and expenses from the losing party. And the second exemption is if the parties have a contract that has a specific provision in it that says a prevailing party in a lawsuit gets its legal fees paid by the losing party. Okay. And that's just general contract law, which gets back, to the one slide we had on the screen a few minutes ago, that indentures are interpreted as just contracts. It's a contract between the property owner and the homeowners association. And because no two indentures are the same, some indentures can have a provision that says, well, if the homeowners association trustees bring a lawsuit against a property owner for example, failure to pay their annual assessment or failure to pay a special assessment or failure to comply with provisions of the indentures about keeping your grass cut short enough, whatever, that the property owner has to pay the HOA's legal expenses. Okay, I've seen other indentures that don't say anything about anyone paying the other party's legal expenses, in which case the American rule is the default. But I have never seen a set of indentures that says, well, if the HOA sues a property owner and the property owner wins, the HOA has to pay the property owner's legal fees. I have never seen a set of indentures that says that. And unfortunately, we probably never will, because again, when like if you have a subdivision that was established 20 or 30 years ago, those indentures were written by, likely a very conservative real estate attorney somewhere. And, the developer didn't, who was setting up, the subdivision and setting up the homeowners association, didn't want the homeowners association to be paying out money if they lost a lawsuit. So that's why I think it's very, very unlikely that we would ever see a set of indentures that has a fee shifting provision like that in it that would allow a property owner to recover from the HOA if the property owner prevails in a lawsuit to interpret the indentures. I'm not saying it's not possible, but I think it's highly unlikely.
Steve, we have a couple questions regarding the new law and how it applies to condominiums. Kind of what's your interpretation of maybe, multiple condominium owners under one roof? How would this apply in a condominium scenario?
Well, condominium law in Missouri is kind of unique in and of itself. I think the language in Senate Bill 820, and Eric, I don't know if you can go back and bring that, or if we should go back and bring that slide up or not, but as I recall, it specifically talks about homeowners associations, regulations that are adopted by a homeowners association. So I think, if you have some condominium associations can be, maybe you can argue that, well, this really is a homeowners association, but then again, other condominiums, can be organized in a different way. Again, I think the answer to the question falls back, to what we were talking about a few minutes ago as well. Each, contract, between the property owner and either the HOA or the condominium organization is unique, and it's going to have to be interpreted on its own. It's really not possible to give a generic answer about what a contract says unless you're looking at the contract.
Yeah, I'm looking at section 3, Steve. I think it says the provisions of this subsection shall apply only with regard to rooftops that are owned, controlled, and maintained by the owner of the individual property or structure. Would that have an implication in terms of condo ownership?
Well, that's the unique thing about a condominium is that there is a property owner that, they own that unit. Not all, if there is a condominium that has a rooftop, arguably, it's possible they could make a legal argument that they would fit under the protections of Senate Bill 820. But again, you'd have to look and see what their condominium agreement says.
Got it. Thanks, Steve. Hope that answered the question. We have a question of, we live in Lake St. Louis. Our rules say solar panels can't face a street. Is this too broad to enforce for the municipality to enforce?
Could you repeat that?
Sure. Our listener lives in Lake St. Louis. The rules in Lake St. Louis say solar panels can't face a street. Is that rule too broad for the city to enforce?
That could possibly be an example of an overbroad municipal ordinance. When the questioner says, these are the rules of Lake St. Louis, when you first read the question, I assumed that she was that they were talking about like a homeowners association in Lake St. Louis. But if they're talking about a municipal ordinance, clearly under the bad case in the provisions in the Missouri Constitution, the city of Lake St. Louis, like any other municipality, can have solar ordinances under its police power authority. However, those ordinances can't be arbitrary and capricious. Pardon me. There has to be some type of articulable legal basis to justify why they're saying no one can have a front-facing panels.
Thanks, Steve.
And if their basis for that is as well, we just don't like the aesthetics. I mean, aesthetics, is, if you look at the definition of aesthetics in the dictionary, it's what an individual, conclusions that they draw after observing something. So two individuals can look at something and come up with completely different conclusions about it. So an ordinance that's based 100% on aesthetics like this, I would say, is much a challenge to that based on this arbitrary and capricious standard. It would be much, much stronger as opposed to if an ordinance said, well, if the example I gave earlier, well, if you can't really have panels situated such that they're going to put glare on drivers if someone's driving down, Highway 40 or Manchester Road, something like that.
Got it, Steve. It does seem like there's lots of cities that have ordinances or ARB policies that require, we deal with this, certain racking color has to match the panel color. They have to be painted black. Any thoughts on kind of that, how rigorous that law is, or is that appropriate for a city to have, just the painting of the racking needs to be a certain color?
Well, I think that under Senate Bill 820, to answer your question in two parts, it's possible that a homeowners association could amend its covenants to have some type of provision like that, because clearly the color doesn't affect the installation, doesn't impair the functioning, doesn't affect the use, doesn't be, unless the black paint costs more and adversely affects the cost somehow. So possibly an HOA could have an or have a covenant like that. Whereas can a municipality include a provision like that in the ordinance? I think under a city's police power, to protect things for public health, public safety, concerns like that, I don't see what the color of a support rack has to do with either of those. So I think a municipal ordinance that mandates what color something has to be is probably subject to an arbitrary and capricious challenge.
Got it. And for many people who live in homeowners associations, their house actually faces south, but they're facing the street. And that's been kind of a bugaboo for homeowners association. This law says that homeowner association can't adversely affect the cost or efficiency of the device. Could a homeowner in an association argue that because we're south facing, if we put the array on the north facing, we'd lose efficiency of the panel? And with this new law? Yeah,
I think that's the classic argument. I mean, if the outcome of a municipal ordinance or an indenture provision, is, well, you can only have them on the north side of your house. I mean, that's why whenever it snows, the snow never melts on the north side of someone's house. You don't get any sun there. So that'd be a classic violation, I think, of this provision in Senate Bill 820.
Got it. Well, Steve, I guess the conclusion maybe would be, you mentioned, I'm kind of taking away the fact that every indentured is different. Everyone, maybe the advice would be to check your own HOA, what the indentures are, what the regulations are, and then fold in kind of what this bill has. And would you just advise people to talk to their people on their HOA board and alert them to this new law starting January 1st?
I think that certainly would behoove people. But again, sometimes, the trustee, again, who was it? Tip O'Neill years ago said all politics is local, and you can't get more local than the people that live in a subdivision and, people that serve as these trustees. I mean, some of the people can be reasonable based on my experience. Some of the people can be dead set on their ways against everything. And, so it depends. You'd have to leave it up to the individual property owner to determine, well, whether or not the HOA trustees would be receptive to hearing about this or not. Some just like their local elected officials or their alderman or a council person, some of them may be, somewhat more progressive in their political outlooks than others. Again, it's just like interpreting indentures. Each situation has to be evaluated on its own. Great.
Well, again, thank you very much, Steve. And again, you're Steve Jeffery of the Jeffery Law Group. I'm sure you'll be happy to answer maybe your questions via email after the webinar. Thank you very much for your time. Thank you, everybody here, for participating in today's webinar. Again, I'm Eric Schneider with Straight Up Solar, and feel free to give us a call at straightupsolar.com if you're interested in going solar or you have additional questions on this topic. And with that, I'll say thank you very much, Steve, for your time. Thank you,
Eric. Thank you again for the opportunity. I really appreciate it. Hopefully the folks were able to get something out of this.
I'm sure they did. Thanks a lot. Thank you very much, Steve. Bye.
Yeah.